Gun licensing across the United States just got blindsided by a Supreme Court emergency decision that flips the entire system on its head. The Department of Justice, the same agency that typically defends permit laws, just flipped teams. Now they are standing shoulder to shoulder with gun owners to tear down Hawaii licensing scheme. Over half the nation instantly piled in to support the move. The opposition is in full panic mode. This is the most significant Second Amendment case in years, and it is about to redefine how every American legally carries a firearm. If you want to know how this will impact your state, smash that subscribe button right now because legislatures are already rewriting laws before the final verdict is even out. Disclaimer: I'm not an attorney, and this isn't legal counsel. Firearm statutes shift quickly and vary by zip code. Always consult a licensed lawyer and your local ordinances before acting. Hawaii, hidden snare. To grasp why this case is detonating across the legal landscape, you have to see what Hawaii tried to pull. After Bruin, the Supreme Court made it clear states cannot hide behind may-issue permit games anymore. That chapter was closed. Hawaii looked at that ruling and built something even more suffocating. Under their new setup, you could only carry on private land if the owner handed you written consent in advance. No sign? You are instantly a criminal. Hawaii was not alone. California, New York, New Jersey, Maryland, Massachusetts, they all watched Bruin and immediately started sketching loopholes. They did not roll back permits, they doubled down. These states rammed through 47 new gun restrictions. Hawaii law made 99.8% of private land off limits unless you had prior written approval. Gas stations, malls, parking lots, all banned by default. This was not regulation, it was erasure. When lower courts signed off, the Supreme Court found itself staring at a law that openly mocked its authority. But one detail makes this case unlike any other, and it starts with who stepped into the ring. The feds switched sides. The Department of Justice. Switching teams in a gun case is almost unheard of, but when Hawaii law hit the High Court, something historic happened. The DOJ filed a brief that basically threw Hawaii under the bus. They told the justices Hawaii setup could not survive Bruin. They said outright it had nothing to do with property rights. It was designed to strangle carry rights through a permission scheme with zero historical basis. The DOJ reminded the court that trespass laws already give landowners every tool they need. So why the blanket ban? Because the goal was suppression, not safety. The DOJ used the word pretextual 4 times, legal code for you are lying. Then it escalated. The DOJ formally asked to argue on the challenger's side during oral hearings. In the last 4 decades, the federal government has flipped sides in a Second Amendment case only 3 times. This is number 3. State AGs started emergency conference calls. Legal defense funds shifted budgets overnight. Everyone realized the battlefield had moved. Then came the landslide. 26 states jumped in to support the challengers. That is over half the nation declaring Hawaii model unconstitutional. This was not backup, it was a legal siege. You already see what this means for other states. But first, you need to see how Hawaii trap actually snared everyday people. How the snare catches citizens. At the heart of it lies one cleverly disguised weapon. Hawaii did not just tweak rules, it redefined permission itself. Instead of you can carry unless told no, they flipped it to you cannot carry unless explicitly told yes in writing. Here is how it plays out. You are a law-abiding resident. You endure Hawaii entire licensing maze, fees, background checks, training, paperwork, you get your permit. Now you walk into a grocery store for milk. You scan for a guns welcome sign. You do not see one. Under Hawaii system, that absence just made you a criminal. The owner did not need to post anything. Their silence became your felony. Hawaii knew exactly what it was crafting. Internal legislative emails spilled the plan. Lawmakers openly discussed how most businesses would not post consent signs and how that quiet would function as a stealth ban. The state AG predicted fewer than 0.4% of businesses would post welcome signs. That was not collateral damage, it was the blueprint. This is Bruin inverted. Bruin said the right to carry is the constitutional default. Hawaii flipped it upside down. The ban became the baseline. If Hawaii can redefine the Second Amendment starting line, what is stopping them from doing the same to the first? The Supreme Court is about to answer. But the real fight is not confined to Hawaii anymore. It is spreading coast to coast, and the fallout is already visible. indivisible. The National Unravealing. This ceased being Hawaii problem the moment the High Court took it up. If they torch Hawaii model, the shockwave slams every state that copied the playbook. California, New York, New Jersey, Maryland, Illinois, Massachusetts, they all built near identical frameworks. If Hawaii collapses, that entire defense crumbles. Here is what makes the timing explosive. Right now, 127 separate lawsuits challenging state carry rules are frozen in federal courts. Not 12, not 50, 127, all waiting for the court signal. The instant the ruling lands, all 127 ignite at once. Plaintiffs will demand immediate injunctions. States will scramble to rewrite statutes. But the cascade is not waiting. It is already begun. New York quietly stopped enforcing 3 post-Bruin restrictions. California delayed 2 upcoming permit rules. New Jersey AG sent prosecutors a memo. Use extreme discretion on permit violations. Translation: do not enforce this, we are going to lose. These are not minor tweaks. These are white flag moments. But what no one is saying out loud yet is the secondary tremor, the financial earthquake, and the numbers are jaw-dropping. The money implosion. 6 permit-heavy states pull in over $200 million every year from licensing revenue, application fees, renewals, mandatory training, processing charges. That is just government cash. Private analysts estimate state-mandated carry training pumps $680 million annually into the economy. Companies printing certificates, ranges built for required classes, software firms selling tracking platforms. When permits go optional, that money evaporates. Hawaii Licensing Division had 47 staff. That dropped to 19 after applications plunged 78%. New York refunded $6.8 million to 14,000 applicants for blocked training classes. California halted its $100 permit fee, losing $1.2 million per month. New Jersey calculated that scrapping permits blows a $41 million hole in the budget with no fix in sight. Illinois projected $33 million in losses. 3 of the 10 largest training companies filed bankruptcy. All listed the same reason: expected regulatory shifts eliminating mandatory classes. But if you think the money angle is massive, wait until you see what is happening to cops and prosecutors enforcing these laws right now. Cops and DAs stand down. Or the enforcement crisis. Law enforcement is stuck. Sheriffs, chiefs, prosecutors are enforcing laws that might soon be ruled unconstitutional. 19 California sheriffs issued a joint statement. They will no longer check carry permits during traffic stops unless another crime is underway. Their reason? We cannot in good conscience enforce a rule the High Court may strike down. That is 19 elected officials refusing to enforce state law, shielding themselves from civil liability. A survey of 340 police chiefs found 62% issued orders used discretion on permit violations, focus on real threats, ignore paperwork. District attorneys in 14 counties dismissed 1,847 pending charges based solely on permit paperwork, not banned possessors, not other crimes, just missing permits for lawful owners. Why? If the court nukes Hawaii, every conviction becomes ammo for a civil rights suit. Defendants will sue. Some will win 6-figure judgments. No DA wants to cut checks for prosecuting under an unconstitutional statute. The Constitutional Crossroads. The Supreme Court is not just reviewing Hawaii statute. It is answering a core question. Does the right to carry begin with the citizen or with government approval? If it is the citizen, every state built on permission first collapses. States have argued for decades that gun rights are unique, that demanding permits is reasonable in ways it would not be for speech or worship. The court already rejected that. In Bruin, power, the individual or the state. The Second Amendment gets the same shield as the first, but permit states did not listen. Hawaii took it to the extreme. You have zero right to carry unless a store owner hands you written consent. Imagine applying that to other rights, needing prior written approval before speaking in a shop. The absurdity is obvious. Legal historians found 0 examples in U.S. history of blanket permission demands to bear arms. States regulated where and how, but never required a license to exercise the right. This is the central issue. Who holds default power, the individual or the state? What the data proves. 29 states now allow permitless carry. 21 transitioned from mandatory to optional. The evidence obliterates fear-mongering. FBI stats show violent crime in constitutional carry states fell 8.2% after going permitless, versus 2.1% in permit states. Vermont never required a license, ever. It ranks among the safest states with the lowest gun homicide rate. Maine adopted constitutional carry. Its rate sits at 1.1 per 100,000, lower than before the law. New Hampshire and South Dakota went permitless. Neither saw violence climb. Permitless carry removes red tape for lawful owners while changing nothing for prohibited persons who never bothered with permits anyway. Implementation differs. Some states went fully permitless. Others kept optional licenses for travel reciprocity. The Supreme Court will not impose one system. It will set a constitutional floor states must honor. The permit regime is not just shifting, it is imploding in real time. States are surrendering before the ruling drops. Law enforcement is backing away. Prosecutors are tossing thousands of cases. The question is not whether this will change. It is how fast your state caves. What the court decides will reshape how 330 million Americans view their constitutional freedoms. Make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.